Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. In today's video, we will understand a fundamental concept of civil litigation, burden of proof, in light of the Bharatiya Sakshya Adhiniyam, 2023. We'll explain how the courts allocate the burden of proving facts, how it shifts during trial, and we'll also go through landmark Supreme Court and High Court judgments that provide real-life judicial interpretation. This video is useful for litigants, law students, and legal professionals alike. 1. What is burden of proof in civil cases? In simple terms, burden of proof refers to the duty placed upon a party to prove the facts it relies upon. In civil cases, this burden usually lies on the plaintiff, who has filed the suit seeking relief from the court. It is the plaintiff's responsibility to produce sufficient evidence to convince the court that the facts claimed are more likely to be true than not. This concept forms the foundation of fair adjudication in civil law. 2. Relevant provisions under Bharatiya Sakshya Adhiniyam, 2023. The concept of burden of proof is now governed by sections 104 to 107 of the Bharatiya Sakshya Adhiniyam, 2023. Section 104 states that the burden of proof lies on the person who asserts a fact before the court and desires a judgment in their favor. Section 105 clarifies that the burden lies on the person who would fail if no evidence is given by either side. Section 106 deals with the burden to prove a particular fact and places it on the person who wants the court to believe in its existence. Section 107 explains that when the admissibility of one fact depends on another, the person asserting the foundational fact must prove it. These provisions replace sections 101 to 104 of the Indian Evidence Act, 1872, and now apply to all civil and criminal proceedings from 1 July 2024 onwards. 3 types of burden in civil litigation. There are 2 types of burden commonly referred to in legal proceedings. The legal burden or static burden refers to the fixed obligation of a party, usually the plaintiff, to establish their claim throughout the trial. This burden never shifts. The evidentiary burden, on the other hand, is dynamic. It may shift during the course of the trial based on the evidence produced by each party. For example, once the plaintiff has made a prima facie case, the evidentiary burden may shift to the defendant to disprove or rebut it. 4. Standard of proof in civil cases. The standard of proof required in civil cases is known as the preponderance of probabilities. This means that the court must be satisfied that one version of facts is more probable than the other. This standard is lower than the beyond reasonable doubt requirement used in criminal cases. A party can succeed in a civil case by tipping the balance ever so slightly in their favor. 5. Landmark Supreme Court judgments on burden of proof. Let's now understand how the Supreme Court has interpreted and applied the burden of proof in civil litigation. In Anil Rishi v. Gurbaksh Singh, 2006, 5 SCC 558, the Supreme Court made it clear that the person who asserts a fact must prove it. The court also explained how the burden may shift from one party to another as evidence is produced and rebutted. In Union of India v. Ibrahim Uddin, 2012, 8 SCC 148, the court emphasized that a plaintiff must stand on the strength of his own case and not rely on the weakness of the defense. In Rangamal v. Kuppuswamy, 2011, 12 SCC 220, the principle was again reaffirmed: a party can succeed only by proving its own case and not just by pointing out flaws in the other side's case. In the case of RVE Venkatachala Gaunda v. Arulmigu Visvesvaraswamy Temple, 2003, 8 SCC 752, the Supreme Court discussed the concept of burden shifting during cross-examination and on the presentation of rebuttal evidence. It also elaborated on the evidentiary value of documents in determining the burden. The earlier decision of Narayan Govind Gavate v. State of Maharashtra, AIR 1977 SC 183, laid down that when a party desires the court to decide based on a particular fact, it must take the responsibility to prove that fact. 6. Important High Court judgments. Several high courts have also added to this understanding through key decisions. In Srimati Sulochana Devi v. Ram Kumar, 2017 SCC Online Dale 9739, the Delhi High Court ruled that even if the defendant fails to file a strong defense, the plaintiff cannot succeed unless they prove their claim with credible evidence. The Bombay High Court, in Ganapat Ishwar Bhai v. Sitaram Narayan, 2020 SCC Online Bomb 1321, held that the plaintiff in a title suit must prove legal ownership through admissible evidence and cannot simply rely on assertions. Similarly, the Allahabad High Court, in Usha Gupta v. Ramesh Chandra Gupta, 2021 SCC Online All 1634, reaffirmed that in cases involving possession or ownership disputes, the burden is entirely on the claimant to prove legal title or right. 7. When and how the burden of proof shifts. As the trial progresses, once a party has presented sufficient evidence to establish a prima facie case, the evidentiary burden may shift to the opposite party. For example, in a civil suit for specific performance, once the plaintiff proves that a valid agreement to sell was executed and that they were ready and willing to perform their part, the burden shifts to the defendant to prove why performance should be refused, such as by alleging fraud or non-performance. However, the legal burden, the duty to prove the foundational claim, remains throughout with the party asserting the fact, unless a statutory exception applies. 8. Practical implications in civil litigation. Understanding burden of proof is crucial for both sides in a civil case. A plaintiff must not rely on the weakness of the defense. Even if the defendant doesn't contest the suit effectively, the court will still ask the plaintiff to prove the essential elements of their case. Hence, it is necessary to produce strong documentary and oral evidence, ensure proper cross-examination, and carefully rebut or defend the opponent's evidence when the burden shifts. Also, admissions, whether in pleadings or during cross-examination, can reduce the burden of proof on certain points, but cannot entirely eliminate the need to establish core facts. 9. Final thoughts and updated legal position. The Bharatiya Sakshya Adhiniyam, 2023 simplifies and modernizes the law of evidence. While the principles related to burden of proof remain largely the same, section numbers and structural clarity have changed, and it is now mandatory to refer to this updated law in all legal pleadings, submissions, and judgments. The concept of burden of proof continues to be central to ensuring justice in civil disputes. A lawyer who understands how to handle this burden effectively will have a clear advantage in court. Conclusion. To sum up, in civil cases, the burden of proof rests on the party who asserts a fact. This burden is defined under the Bharatiya Sakshya Adhiniyam, 2023, and supported by a long line of Supreme Court and High Court rulings. Knowing when the burden shifts and how to respond with proper evidence and strategy is essential for a successful case. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind!